Hi, this is Chef Skip. Let's discuss Chapter 9, Risk Management. To avoid liability in a food service facility, a manager must prove that they took every precaution to reduce, prevent, or eliminate a risk. Liability is the major cost in lawsuits. Punitive damages are the higher monetarily. Protecting guests and employees from harm includes addressing potential safety hazards such as knives or slippery floors, as well as other health hazards such as chemicals and heat. It also involves establishing a positive work environment, free from harassment, to motivate your staff. Each restaurant guest and employee has the right to enjoy a safe environment on safe premises. So, restaurant and food service operators need to be aware that they are responsible of possible liabilities regarding all of the property around the restaurant, the premises, as well as the conditions inside. Liability means the legal responsibility that one person has to another. These responsibilities are serious because they are enforceable by law in court. Failure to provide a safe environment, possibly resulting in an accident, can result in a loss of reputation, fines, and/or lawsuits. So management needs to focus on the following: what potential hazards are in and around the operation, the necessary steps to correct hazards, and how to display proper warnings where anyone can see them. Developing an effective safety program helps managers to provide reasonable care. Reasonable care is a legal term that means that an ordinary person would think that the operation takes thoughtful and careful precautions. A written safety program that is made part of the operations employee training program and daily procedures can be used as evidence that the operation took reasonable care in case legal situations ever develop. While it is impossible to eliminate every possible risk, restaurant and food service operations have to make the workplace as safe as they can. Safety refers to all sorts of things: an operation's premises, its tools, its standards, and its environment. The Fair Labor Standards Act, FLSA, is an example regarding safety in the law that shows how broad the coverage actually is. The Fair Labor Standards Act is a federal law that addresses the activities that young employees are allowed to do. In effect, it identifies what they can do safely. Check your local and state laws, which may have a stricter guideline. The Fair Labor Standards Act ensures that young people, those under the age of 18, do not risk their health, well-being, or educational opportunities. They can work unlimited hours except in situations that are declared hazardous. Hazardous equipment includes power-driven meat processing machines, meat slicers, meat saws, patty forming machines, meat grinders, meat choppers, commercial mixers, and power-driven bakery machines. They are not allowed to operate, feed, set up, adjust, repair, or clean any of these machines. Employees 14 and 15 years of age. There are restrictions on number of hours they can work and what they can do. They can work in food preparation but cannot perform any baking activities, and they can only perform limited cooking duties. They cannot engage in cooking except with gas or electric grills. They do not involve cooking over an open flame, deep fat fryers that are equipped with and utilize devices that are automatically lower and raise the baskets in and out of the hot grease or oil. They can prepare and serve beverages and use machines appropriate for performing this, and other work such as dishwashers, coffee grinders, milkshake blenders, popcorn poppers, and microwaves that do not warm above 140 degrees. They may clean kitchen surfaces and non-power driven kitchen equipment only when temperatures of surfaces do not exceed 100 degrees. They can filter, transport, and transpose of grease only if the temperature does not exceed 100 degrees. They cannot perform any duties hazardous for 16 to 17-year-olds. They cannot use power-driven food slicers, grinders, choppers, cutters, and bakery-type machines in any capacity. They cannot use automatic broilers, fryer-laters, rotisseries, or pressure cookers. They cannot perform work in a freezer or a meat cooler. The Occupational Safety and Health Administration, otherwise known as OSHA, is the federal agency that creates and enforces safety-related standards and regulations in the workplace. Employers are required by law to inform employees of job safety and health protections provided under the Occupational Safety and Health Act of 1970. Every restaurant and food service operation must display an up-to-date copy of the OSHA poster, Job Safety and Health is the Law, or the state equivalent, where employees can easily see it when they report to work. This poster is so important that employers cannot post photocopies or versions that are smaller than the original or changed in any other way. This is a small copy of that poster. OSHA requires the submission of specific forms regarding the investigation and reporting of accidents, injuries, and illnesses. For example, a restaurant or food service operation is required to do the following: report any accident resulting in death or hospitalization of 3 or more employees within 8 hours of occurrence. Record other employee injuries and illnesses within 6 working days, and maintain a year-long log of occupational injuries and illnesses known as OSHA Form 300. Post a summary of these work-related injuries and illnesses, OSHA Form 300A, easily accessible to employees from February 1 to April 30 of the following year. Despite all attempts to provide a safe environment, accidents can happen. An accident is an unplanned, undesirable event that can cause property damage, injuries or fatalities, time lost from work, or disruptions of work. Accidents are often referred to as incidents or events for risk purposes. A near miss is an event in which property damage or injury is narrowly avoided. Any event that makes guests or employees feel less safe should be investigated and recorded, even if an actual injury did not occur. Each operation is required to have forms for reporting injuries or illnesses involving both guests and employees. An accident investigation involves 8 steps. 1. Record information as soon as possible after the event occurs, ideally within 1 hour. Use OSHA required forms as well as appropriate corporate or company forms. 2. Include a description of the event, the date, and 2 signatures on accident report forms. 3. Collect physical evidence or take pictures at the site of the event. 4. Interview all people involved and any witnesses. 5. Determine as clearly as possible the sequence of events, the root causes and effects, and the actions taken. 6. Submit reports to OSHA, the insurance carrier, a lawyer, and corporate headquarters as appropriate. Keep copies of all reports and photographs for your files. 7. Keep all employees informed of procedures and hazards that arise from the situation. And 8. If they are not already available, post emergency phone numbers in public places. OSHA Form 300A, an annual summary of work-related injuries and illnesses, must be posted by February 1 each year in a common area where employees can easily see it. A hazard communication program is another critical OSHA requirement. The Hazard Communication Standard, or HCS, is also referred to as Right to Know and HAZCOM. HCS requires that employers notify employees about chemical hazards present on the job and train them to use the material safely. Chemicals can be considered physical hazards, health hazards, or both. Physical hazards are chemicals that can cause damage to property and immediate injury, most commonly burns. These chemicals can be flammable, explosive, highly reactive to air or water, or stored under pressure. Health hazards are chemicals that cause short or long-term injuries or illnesses. They include chemicals that are toxic or poisonous, carcinogenic or cause cancer, irritating or corrosive, or cause material to be eaten away or dissolve. OSHA also requires chemical manufacturers and suppliers to provide a safety data sheet, or SDS, for each hazardous chemical they sell. SDSs are often sent with the chemical shipment. Purchasers can also request them from suppliers and manufacturers. Employees have the right to see the SDS for any hazardous chemical they work with, so sheets should be kept where employees can access them. The information contained in the safety data sheets includes instructions for safe use and handling, physical, health, fire, and reactivity hazards, precautions, personal protective equipment or PPE to wear when using the chemical, first aid information and steps to take in an emergency, manufacturer's name, address, and phone number, preparation date of the SDS, and hazardous ingredients and identity information. Given everything that needs to happen to create a safe environment, it's easy to see why companies need safety programs. Safety program guidelines are based on existing safety practices and the insurance carrier's requirements. A safety program is designed to meet specific needs of the operation. It also includes specific guidelines reflecting the operation's geographic location, such as snow and ice removal, flood water drainage, or earthquake response plans. The purpose of a general safety audit is to judge the level of safety in the operation. It is a safety inspection of facilities, equipment, and employee practices and management practices. A general safety audit identifies any areas or practices that might be hazardous to employees and guests. The completed audit is presented in a checklist form. This slide is an example from a general safety audit. Any no response or blank space, which means the inspector could not find the information, requires follow-up. Regular safety self-inspections can help make sure that all employees are using correct safety practices throughout the operation. The safety audit covers 4 general areas: facilities, equipment, employee practices, and management practices. Facilities include the building, exterior and interior, and major systems such as electricity and plumbing. This includes outside areas such as drive-through windows, parking lots, and outdoor eating areas, as well as furnishings such as booths, tables, and chairs, and fixtures such as sinks, lights, and doors. All equipment, cooking and cutting equipment, refrigerators, tools, vehicles, fire extinguishers, alarms, etc., must meet the legal standards for food service equipment and be maintained in acceptable working condition. If equipment needs repair, the employees who use the equipment must tell the team and their supervisor. If a machine poses a hazard, then the machine itself should be turned off. A certified technician is the only person qualified to repair equipment and determine that it is safe to use. 2 organizations that label appropriate equipment are the NSF and the Underwriters Laboratories. Managers must train employees in safe practices, then supervise them to make sure they use these practices on the job. Training includes proper use of work equipment. Using equipment incorrectly can lead to equipment problems and potential injuries. Management must make a commitment to protecting employees and guests. When violations or accidents occur, it can mean that the safety program needs improvement. People should only do jobs that have been trained for and are physically able to do. The staff should be updated and retrained whenever new pieces of equipment are purchased or major aspects of the operation change. A strong safety program can lower operating costs, increase profitability, and raise the overall quality of the dining experience. In addition to safety programs, restaurant and food service operations need emergency plans. The purpose of an emergency plan is to protect workers, guests, and property in the case of an emergency or disaster. For an emergency plan to work, all employees must understand it before there is an emergency. Good planning can prevent confusion, reduce fear, and minimize injury and loss during an incident. Emergency plans are specific to each operation and should be posted in highly visible areas. The following considerations should be made as part of your plan: floor plans of the facility, noting first aid stations, alarms, sprinklers, and fire extinguishers, evacuation routes, emergency telephone numbers for each type of emergency. The main parts of an emergency plan are installing fire safety equipment, developing and posting evacuation routes, keeping exit routes clear, and training and drilling employees on their roles during an emergency. Americans spend a lot of time at work, so it is important that the operation has a positive work environment where every employee in the workplace feels respected, safe, and treated equally. This is something you can help with by making sure you treat your coworkers well. And as a manager, you will not only have to create that environment by enforcing rules that dictate how the entire staff should behave, but you will also have to lead by example in how you treat others. 2 critical aspects of a positive work environment are respectfulness and equal treatment for all employees. In a harassment-free environment, complaints are handled appropriately and a workplace that is respectful of everyone is supported. Harassment happens when slurs or other verbal or physical conduct related to a person's race, gender, gender expression, color, ethnicity, religion, sexual orientation, or disability interferes with a person's work performance or creates an unhealthy work environment. Harassment categories include race, color, age, religion, sex, including pregnancy, national origin, disability, or genetic information. In some cases, specific local laws also make discrimination based on sexual orientation illegal. Everyone has the responsibility to prevent harassment. Preventing discrimination is just as important as responding to it, for the welfare of everyone in the operation and the business itself. Most companies have some type of harassment-free workplace policy that provides guidelines and procedures for how to behave in the workplace. Company policies need to adopt a prevention approach, acknowledging mutual respect as a goal for all who work within the environment. The purpose of these policies is to provide a productive and pleasant work environment for all employees. Each organization will have its own policy regarding harassment, but in general, these policies should accomplish the following: emphasize mutual respect for all, state the values of respect held by the organization, state that all staff is expected to adhere to the policy, define the areas covered by the Civil Rights Act, address and covered situations as defined by respective jurisdictions, but also consider expansion based on other types of abuse not covered by the civil rights law. Alert managers to their responsibility for maintaining a harassment-free environment. Give employees options for help with dealing with harassment. Allow for informal resolution if the affected parties choose it. Indicate the process for handling the complaint, and indicate that the organization has no tolerance for disrespectful behavior and misconduct, either of which may result in disciplinary action, including termination. Policies must be in place so that any employee who feels harassed is encouraged to voice his or her objection to the offending person and bring the subject to the attention of a manager. The following guidelines can be used in a complaint resolution or management process. An open door policy should be put into place, as well as directives that protect person with complaint, called the complainant, from retaliation. Complaints should be reported initially to the complainant's direct supervisor or manager, unless the supervisor or manager is the subject of the complaint. In that event, the next level of management or human resources representative should receive complaint. The complaint should be processed in accordance with any local, state laws and follow the company policy. Complaints should be investigated thoroughly by the complainant's direct supervisor or manager, unless the supervisor or manager is the subject. If the complaint, in that event, the next management level or human resources representative should conduct the investigation. In all cases, investigations must be done in confidence. Employees should be prohibited from discussing the situation with other employees. Managers should communicate the information with only the appropriate parties. Managers need to document the complaint and collect statements from all involved parties. If the investigation reveals an employee has harassed someone, the offender must be subject to appropriate disciplinary procedures, including termination. Managers are legally liable for maintaining a harassment-free environment. In fact, managers at all levels, including company presidents, have been cited and fined for not dealing with harassment effectively. So managers must acknowledge and respond to complaints immediately, as well as act upon any type of harassment they see or become aware of. The best approach is a proactive one that upholds applicable laws and promotes the company guidelines and policies.